So in Philadelphia, for example, where we have a class action lawsuit going, the median amount of a cash forfeiture on the streets of Philadelphia is $134. Thanks, Trevor, for having me on such short notice. No, it's nice to be here. This is a particular interest of mine. It's been a fascinating conference. I've enjoyed the opportunity to come and hear people speak. Before I dive in, I wanted to help you guys out with something you may be wondering about. In Jerry's presentation, he had a Philly magazine article online up on the screen. Did anybody notice what was the #1 story that day? It was that it's now legal to deliver beer in Pennsylvania with food orders. And so I checked, and it's true. You can get up to 12 tall boys of beer delivered with your pizza in Philadelphia. So in case you were wondering what was going on with that story, now you know what you can do in the city of brotherly love when it comes to getting a buzz with your pizza. So I want to pick up on a theme that seems to be sort of interwoven through a lot of the presentations today, and one that I think is incredibly important for the overall subject matter, and that is the public perception of police legitimacy. Without a solid basis in public confidence and public support, it's very difficult, more difficult for our law enforcement officers to do their job. And I want to talk about one policy in particular that I think is maybe one of the greatest threats to public perceptions of legitimacy of law enforcement, and that is civil forfeiture. Notice I don't use the term civil asset forfeiture because I think that puts the emphasis on the wrong place, and it makes it sound like we all go around with these assets, like my car, oh my God, I got this asset. No, it's civil forfeiture. And what that means is taking people's property without convicting them of a crime. That's what civil forfeiture is. And my organization has a study that we just updated this month called Policing for Profit. And unfortunately, that really summarizes the issue in the minds of many people, that this policy, civil forfeiture, has created a system in which at least some of our law enforcement is in fact engaged in policing for profit. And unfortunately, that's it's an accurate perception, at least in some settings. And I think that it's been terribly damaging for the perceptions of public legitimacy. Let me start off with a quick anecdote. I've litigated some of these forfeiture cases, by the way. The Institute for Justice considers this a property rights issue, and we have a very active civil forfeiture practice. I've litigated some of those cases, so I'm quite familiar with this area. But I want to convey an anecdote, a case that I'm not personally involved in, but I think illustrates in some ways one of the biggest problems in this area, and that is the problem of perverse incentives. There was a local TV station in Tennessee that documented a curious fact, and that is that along Interstate 40, which runs across the state of Tennessee, they noted that these drug task forces, Tennessee has drug task forces, multi-jurisdictional law enforcement groups that get together, try to interdict drug traffic. What they noticed was that these drug task forces were setting up on the north side of I-40 90% of the time instead of the south side. Can anybody think why there would be such an interest in setting up on one side of the highway instead of the other? It turns out to be quite simple. The drugs are generally moving from western states to eastern states. So you've got drugs coming in from California, Arizona, Texas, and they're moving to the East Coast for sale. So the cars that are on the south side of the interstate moving east are full of drugs. The cars on the north side of the interstate moving west are full of what? Money, after the drugs have been sold. And guess which side of the interstate these task forces set up on 90% of the time? Not the side that would enable them to interdict the distribution of these drugs to keep this deadly poison off of our streets. Oh no, they set up on the other side of the highway so they can get the money. And I mean that literally, they get the money. It's not that the officers actually put the money in their pocket. Well, they're not supposed to. I'm sure that happens. But no, as a matter of official policy, the money, the proceeds from these forfeitures go into law enforcement budgets, which is the second worst thing you can do, besides allowing police officers to simply keep it individually. So you have this tremendous incentive that warps law enforcement priorities, or maybe I should say can warp law enforcement priorities, to have them not only investigating and working on crimes that may not be the most serious crimes in terms of the overall health of the community or people's well-being, but that also reflect an interest in advancing the budgetary interests of that department more than public welfare. Now, I'm not going to suggest that this happens all the time. I'm not going to suggest that it happens in every department. What I will say is nobody knows how often it happens, just that it happens quite a bit. By the way, the Tennessee situation that I described is far from the only area where this has ever been shown, this distortion of law enforcement incentives. Police have been frequently shown to be more interested in interdicting cash than interdicting drugs. I mean, that's a huge problem. So where did civil forfeiture come from? Why do we have civil forfeiture? Well, there are two kinds. There's criminal forfeiture and civil forfeiture. Criminal forfeiture is, I think, unexceptionable. It's the kind of thing that happens when you accuse somebody of being a big-time drug dealer. You prove in court, or else they sign a plea agreement confessing that they've been bringing in large quantities of drugs from off, the Florida Keys in a speedboat. So you get to take the speedboat after you convict them of the crime of distributing drugs and show that the speedboat was used to facilitate that crime. If they stored the drugs in a house and used that as a distribution point, you get the house too. Again, after you've convicted the person of the crime of distributing drugs and shown that the house was used in the commission of that crime, and so on and so forth. If they had a sports car they were using, et cetera, you get to take that. And if they had a giant stack of money in the house, you get to take that. Civil forfeiture is quite different. Civil forfeiture does not require a criminal conviction. It doesn't even require that you indict the person or even arrest them for the crime. All the law enforcement has to do to initiate civil forfeiture is simply seize the property. It might be a car, it might be a bunch of cash inside the car, it might be somebody's home. But it can be done on the basis of nothing more than probable cause, which is nothing. Probable cause is simply, it's a little more than a hunch, but in most jurisdictions, it's not much more than a hunch. It's simply a non-fanciful reason to believe that particular property may have been involved in a crime. And notice I said particular property, because that's a very odd quirk about civil forfeiture. It is, in fact, a civil proceeding. It is a civil lawsuit against who or what? Not the person, not the property owner. It's actually the property itself. And you get these bizarre case names as a result, like United States versus $34,516.18. I worked on that case. That was the entire contents of the business account of our two clients, Terry Deco and his daughter Sandy, who lived and ran a store 20 miles outside of Detroit, Michigan. The IRS Criminal Enforcement Division concluded falsely on the basis of zero investigation beyond looking at their bank records that they were engaged in the federal crime of structuring, which is where you break up your cash deposits at a bank into amounts less than $10,000 to avoid the reporting requirement. In their case, they were deliberately depositing less than $10,000 at a time because they had a small business insurance policy that, like most small business insurance policies, cuts off cash losses at $10,000. Apparently no one at the IRS has ever run a small business, so they were unaware of this fact. They've ruined a lot of small businesses, but they've never run one. And had anybody bothered to ask Terry Deco why he was making so many deposits under $10,000 and had been doing so for 25 years, he would have been happy to show them his insurance policy and say, because my insurance broker and my accountant said don't allow more than $10,000 in cash to accumulate in your store. But no one asked, because you know why? They didn't care. What they cared about was getting that money. And the way they got it was to go to the local federal district judge and get an ex parte warrant, meaning a secret warrant, that in my experience, federal judges hand out like Halloween candy. You go to the bank, you seize the entire account, and then you go over to the store to do a victory lap and let them know you've just taken the entire bank account. And happened to be on the day that Terry was trying to pay all of his vendors, which caused the store to almost go bankrupt. Let me just add, that store employed 28 people. If you employ 28 people within 100 miles of Detroit, you deserve a medal, not a subpoena or a search warrant from the IRS taking your entire bank account. But anyway, so you get these bizarre cases, United States versus X amount of money. United States versus a 1986 Ford Thunderbird is an actual case. My favorite one, United States versus one solid gold object in the shape of a rooster. I can imagine what they call that caper for alliteration. Thank you. All right. So civil forfeiture had its origins in 15th or 16th century England when they used it to seize the ships and contraband belonging to people who were trying to run blockade or run the British had a law that you could only deliver goods to England or Britain in British flag ships, and so other countries would have an incentive to try to get around those, and so you used basically an old-time version of civil forfeiture to seize the contraband in the ship. So this fiction that the property could be guilty of the crime made it across the Atlantic, where it was used during the colonial era here in America, and then it essentially went dormant until when? Well, until first prohibition, until the prohibition of alcohol in 1919, and then suddenly you saw the use of civil forfeiture, but nothing like on the scope we see it today. And once again, after the repeal of prohibition, it went dormant until when? Until the advent of Prohibition 2, drug prohibition, and then civil forfeiture exploded. And what do I mean when I say exploded? Well, the Department of Justice maintains something called the Asset Forfeitures Fund. In 1986, the annual revenues or the annual deposits of the DOJ's Asset Forfeitures Fund were $93.7 million. That's million with an M. In 2014, the last year for which figures were available, $4.5 billion. If you look at the entire federal government, not just DOJ's Asset Forfeiture Fund, in 2001, the amount of deposits of forfeitures for the entire federal government, $500 million. In 2014, $5 billion. Forfeiture has exploded, and most of it is civil. We're not sure exactly how much. Why? Because the federal government doesn't break it out. DOJ keeps track of 1,300 different bits of information about forfeiture. Not one of them involves the distinction between civil and criminal. We had to dig this information out of the records through open records request from DOJ. So they keep track of 1,300 different things. They have no idea how much of their forfeiture comes in the form of criminal versus civil. And it matters a lot, because with criminal forfeiture, lots of due process. With civil forfeiture, virtually no due process. So it matters tremendously, and DOJ has no idea. There's another problem. In 15 minutes, I couldn't possibly tell you everything that's wrong with civil forfeiture, but I'm going to hit a couple of highlights. Another big problem is the ability of the federal government to distort local law enforcement priorities. I'll give you one example. States that have moved to decriminalize marijuana or outright legalize it, there is still a federal law against the distribution or even the possession of marijuana, and the federal government has said in many instances that it will continue to enforce federal law, even in jurisdictions where it has been made legal. We actually had a case in California where we had a client who rented out a piece of commercial property to a medical marijuana sales front, and it was perfectly fine under state law, but the City of Anaheim Police Department wanted to go after the guy anyway, even though it was perfectly legal as a matter of state law, so they went to the feds, and they invoked a policy called equitable sharing, where the federal government can come in, and simply by participating in the investigation, they can essentially federalize the forfeiture. So what they proposed to do, we were able to stop it in this instance, but what they do all the time is just have a little federal involvement in a forfeiture matter. The federal government will be the official seizing agency, and then they'll basically kick back up to 80% of the proceeds back to the local jurisdiction. Again, even in states where it's a violation of explicit state policy, the federal government forfeiture program is being used to pervert local preferences, and that's a huge problem. A couple other problems with civil forfeiture. There's a virtual absence of procedural due process. I can't catalog all the ways in which it is absent, but I will tell you this. About 90% of federal forfeitures are accomplished administratively, and what that means is no one bothered to challenge it. DOJ draws one conclusion, namely, we've got a really accurate success rate. We're getting property from bad guys who know they shouldn't bother to challenge it. We tend to draw a different conclusion, which is that it is so difficult to challenge a civil forfeiture. And believe me, I've worked on these cases. The procedures are mind-numbingly complex. They make the tax code look like child's play. That no matter how innocent you are, the idea that you can go out and hire a lawyer and simply get your property back is utterly fanciful. Another problem, virtually no transparency. As I mentioned before, DOJ keeps track of 1,300 different bits of information about its forfeitures. None of that pertains to whether it's criminal versus civil. That extends also to local police departments. It is virtually impossible to find out how much money they're taking in and what they spend it on. And we've been trying to dig this information out of the federal government and local law enforcement agencies for over 5 years now, and it comes in dribs and drabs. So one of the biggest problems with civil forfeiture is there's just nobody who has any idea of what its scope is and what the money is being spent on. None. Every once in a while, something funny will pop up. There's a DA's office in Texas that used some of the civil forfeiture money to buy a margarita machine. If that made them less effective at doing civil forfeiture, I guess maybe that was a good thing. Net, I'm not sure. There's a few problems that I'll just touch on really quickly with moving in the direction of reform. One of the biggest problems is supporters of asset forfeiture say and maybe even believe things that are just not true. So one thing they'll tell you is you have to have civil forfeiture to enable you to take down these drug kingpins. Well, first of all, if the guy's a kingpin, charge him and convict him. Shouldn't be too hard. He's a kingpin, right? Second, it's statistically not supported. So in Philadelphia, for example, where we have a class action lawsuit going, the median amount of a cash forfeiture on the streets of Philadelphia is $134. I mean, I guess they have a different definition of kingpin than I do. Maybe I just missed something since I stopped watching Miami Vice in the 1980s, but I thought it was a bigger deal. In Washington, D.C., it was even less. It was about $100. So that's the big-time drug dealers running around Washington, D.C. with $100 in their pockets, but it's definitely being taken. Another myth that supporters of civil forfeiture tend to cling to, which I can tell you is absolutely false, is that there's a process for getting the property back. Actually, that part's true. There is a process, and it is completely rigged against the citizen. Just to give you one example, the infamous courtroom 478 in Philadelphia is where you have to go to contest forfeitures when the police take your property. It's not a courtroom, actually, because you know why? There's no judge in courtroom 478, at least not until about the 5th or 6th time you show up. When you show up the first time to contest a forfeiture, you meet with a prosecutor, and they essentially give you a schedule, and you have to come back 4 or 5 more times. And believe me, those are just hoops. And if you miss even one of those other appointments, then you default, and they take your property. Maybe the 5th or 6th time you actually get to go in front of a judge, but if you're one of these people who had $134 taken, how many days can you really take off work to get your $134 back? And you think the Philadelphia District Attorney's Office understands that dynamic? Oh, they understand that dynamic, trust me. Final point is they'll tell you that abuses are rare. How in the world would you know? How do you know they're rare? You hope they're rare. I get that you hope they're rare. But the point is you have no idea whether they're rare. We know they happen, and I can't tell you what percentage of the time there are abuses because I don't know either. And that's the problem. Nobody knows. But you have a process, civil forfeiture, that has perverse incentives, namely law enforcement gets to keep the proceeds, and virtually no due process. All right, so what can we do? Reform. This is the short part of the talk. End it. End civil forfeiture, root and branch. New Mexico just did that a couple months ago. That's the right direction. If you can't end it, then you do 3 things. Eliminate the profit incentive. All civil forfeiture proceeds should go into a general fund, not a law enforcement fund. Second, you have to restore some procedural due process so that ordinary people who've had their property taken illegitimately can challenge the process, which is completely impossible now. And third, more transparency, a lot more. Thank you.